Welcome, everybody. Folks are arriving here, just wanting to greet folks from the Minnesota Elder Justice Center to our Thursday webinar. We'll just give a minute or so here, maybe to 12:01 or 12:02, Renee, for folks to flow in. All right.
I think so. We have such a great audience ready to learn about probate and ownership.
Excited.
Yes. So it takes a while for our audience to grow, but we'll let them in.
Right on. Excellent. Just a few more minutes. I'll mute for a minute here, Renee, while folks are arriving, and then I'll unmute in a moment and we'll get going. All right, welcome everyone. I see folks are still arriving. And I think I will get started as the numbers are kind of rolling here. Just to greet everyone and welcome folks to the Minnesota Elder Justice Center webinar. My name is Marit Peterson. I'm the Associate Director, and I'm here with Renee Strami. You know Renee. Hi, Renee. Thank you for joining us today. This is the Minnesota Elder Justice Center Thursday webinar. And today we're talking about probate and ownership basics. So really jumping into an introduction around some of the questions that arise when someone dies. That was our subtitle today. And we just want to thank the Minnesota Board on Aging. This webinar is supported in part by a grant from the Board on Aging. So as to the Minnesota Elder Justice Center, I want to talk a little bit about our organization and just do some housekeeping as we get started here. First, here's our organization, and you can see our mission, our values, and our work areas here. You can see that we work in public awareness, professional education, that's part of our webinar series that we're doing here today, public policy, and direct service. And I'll talk a little bit more about these areas of work as we go. But in particular, I want to mention that if you'd like to connect with our direct services, you can reach a victim services advocate in our office by calling the number here, 651-440-9312, or you can reach information about our victim services from our website. We have a form there that will allow you to engage an advocate in our victim services, the victim services team, and or other information about connecting with our organization available online there. We also have a number of free webinars that are coming up. And so just to share a little bit about our upcoming schedule, you can see here our next webinar is coming up on the 23rd, on March 2nd, 9th and 16th. Renee's got them scheduled out for a couple months, and we're really excited to be talking about some of these issues. We're going to hear a little bit about adding a power of attorney or trusted person from the perspective of financial firms who are endeavoring to provide financial services to folks under various circumstances. So we'll hear more about legal services on March 2nd and more about resources for individuals with Alzheimer's and related dementia on March 9th. And then more on power of attorney on March 16th. We just always have opportunities to talk about this mode of substitute decision making that comes up so often for folks. So looking forward to some of this content and hoping that you will join us. As you know, these webinars are free to you, and that we offer CEUs. We are pre-approved to offer social work and BELTS CEUs for these webinars. Many other providers also accept webinars based on self-reporting. Nurses, for example, are able to self-report using webinars offered by the Elder Justice Center. Renee, will you clarify if I need to be more clear about any of that? but otherwise,
We
go ahead.
will, yeah, when we get to that, there is a slide that indicates the
Yeah.
CEU, but we do have pre-approval with the social work and belts, and that the Board of Nursing has reviewed and said that our webinars tend to meet the standards for nurses, though it is the obligation of the nurse to verify that it matches those requirements. A very confusing way to say it, I'm sure, but they see them as valuable.
Excellent. Thank you, Renee. We were pleased to hear that and hope if you are a nurse and in our audience today, that this is valuable to you. And we thank you for being here. Other types of self-reporting should be addressed by the certificate that we provide to you via email after the presentation. So you'll see here, we will send along the slide set, we will send along the certificate, and we will post a recording of this presentation on our website. You can see the link to our recordings here on this slide. And then, as I always do, and I know Renee too, you will be asked to provide feedback both on this webinar and to share any ideas about other educational content about which you'd like to hear via a survey at the end of the webinar. You'll be automatically given the opportunity to answer those questions, and we are so grateful to you for doing so. It should just take a few moments of your time, maybe just a couple minutes, but your suggestions and recommendations really help us make decisions about what presentations to feature in the webinar series, where we should direct our energy in terms of creating and providing additional education. So we're tremendously grateful to you for the time you take to guide us in that way. Thank you very much for that. I'm going to go backwards by a slide to just talk a little bit about the circumstances for this webinar today. So we're all on mute, but we really encourage participation in questions. The goal of this was to be able to answer questions that might arise for you, particularly in your role providing services to older adults in Minnesota. If you'd like to engage, if you have a question for me, there's a Q&A box you'll find there at the top of your screen, a little icon that says Q&A. And if you have questions for me regarding the content of the presentation, please use the Q&A box. And then there will be a lot of information flowing in the chat as well. And that's just a tremendous, something I appreciate tremendously about these webinars. The other folks on the webinar today are a tremendous resource to us all. The chat is often filled with information and insight from other practitioners in the field, commenting not only on the remarks that I'm making, but also sharing information about resources that they have used successfully or ideas that they have. So please don't hesitate to use the chat to share information in that way. I really welcome that, and it's very, very beneficial. There is also auto-generated captioning. So if that would be a benefit to you, you may click, there's a link here that says live transcript, and you may enable the auto-generated captioning under live transcript by clicking that. The captioning is good but not great, I'll say, or good or fine. If you have questions about anything that appears in the captioning, please feel free to ask, and we're happy to provide clarification. I did talk a little bit about CEUs, recordings, and feedback. And I just want to take a moment to say, if you do appreciate these learning opportunities, although we do not charge for them, they are not free to create. So we are very grateful for the support that many have provided to us. This type of support does enable us to continue to provide these webinars at no charge to our webinar audience. So we're really grateful to have the ability to do that, and tremendously grateful for the support that others provide to us in doing this work. I said before, my name is Marit Peterson. I'm the Associate Director of the Minnesota Elder Justice Center. And then I'm an attorney by training. And so I have some insight and perspective onto these questions about what happens when someone dies, because in my own prior professional life, this was an area in which I practiced. And so I think a bit about what it means for individuals and families to face these questions from the perspective of an attorney in this context. But now, as the Associate Director of the Elder Justice Center, I have the privilege of getting to think and about and talk with professionals, others who are serving older or vulnerable adults in Minnesota. And in so doing, have had a chance to reflect on their questions on these themes as well. So I'm really grateful for the ability to have those perspectives, both from a consumer perspective as well as from those who are doing this work alongside us all. So thank you for that. And that's me. And thanks to Renee for all of the work that she does in preparation for this webinar series and in preparation for the great content that we have upcoming. I'll take a moment and offer a visual description of myself as I get started. My name again is Marit Peterson, and I am a white woman with short brown hair, and I'm wearing eyeglasses today, sitting with a headset on and a turtleneck in my office. And I will get started now with our questions here. What happens to the things we own when we die? We talk about this at the Minnesota Elder Justice Center because we know these questions arise for families that we're serving. We receive questions related to what happens to things when somebody dies on our helpline. And we know that as professionals, sorting out all the complex processes that can begin when a person dies can be a challenge, and that as professionals, you are often the folks who are being asked these very questions by family members who are concerned, curious, uncertain about what to do next. So we just want to periodically offer a little bit of information about some of the things that happen procedurally when we die, particularly related to ownership. And so I'll elaborate a little bit more about that. Again, I really want to encourage information sharing in the chat and questions in the Q&A. I actually had Renee received a number of questions, and I have them, and I have incorporated them into the presentation. So if you submitted a question ahead of time, you may see your question addressed as the presentation unfolds, particularly towards the latter half of the presentation as I begin to incorporate just some of the direct questions. But that's not to say that if you have a question, you should not put it in the Q&A. Please do, and I will attempt to answer it as we go. So we're talking about definitions today, just basics of ownership and what it means for ownership to be transferred from one person to another. We're going to try to talk a little bit about testamentary tools, such as wills in particular, and then I'll touch on trusts. I just want to make kind of a contrast there. And then I want to talk a little bit about resources that are available for our clients, some consumer focused resources that clients can address or participants can consider if these questions are arising for them. So ownership in general, and just as we're doing some definitions here, so we're on the same page, we're talking about the ability to use, possess, and dispose. And I'm going to talk about what those things mean. To use something, of course, is to be able to enjoy the benefit of it. So for the purpose for which it's intended, for some other purpose that I have identified as useful, but I'm enjoying the benefit of the object, item, principle, concept. Possess means to use, so to enjoy the benefit of, and to control. And the hallmark of control, here we have some language from a case, is the ability to admit and exclude others. So you can see this has direct applicability, the language used here in this case, in concepts around real property. I'll talk a little bit about that, real property or real estate, but also the ability to admit and exclude can be related to personal property as well, to admit somebody to examine something or to exclude them from being able to handle, have, or examine something. So applicability widely here, but so we talk use, possess, and dispose. So possess has to do with this control. And then dispose is, of course, giving away. And that is really, in some sense, what we're talking about when we talk about estate planning, right? So I want to talk about how I dispose of the things that I own, my disposition. This is what we're speaking about. So enjoying the benefits of, admit or exclude, and give away. These are hallmarks of ownership. And with regard to real property, we refer to this ownership as title, holding title to something. This is historic kind of language, or language that comes from historic use. So we talk about title meaning the ability to use, possess, and dispose of, to own something. And that the property is anything that can be owned. So items, attributes, things that are tangible, physical things, keepsakes, and also intangible things. So we can own a trademark, for example. That's something that I can have an interest in, with that, which I can use, possess, and dispose of. So some interesting questions here on property. Real property, it has to do with immovable things, structures, bridges, land. So there were some questions about distinctions in ownership between personal property and real property. Anything that's not real property, or real estate maybe is a version of that, a language that we hear more commonly. Real property or real estate, anything that's not that is personal property. So any property that's not real property is personal property, means belonging to the individual, but not immovable, portable. An estate is the stuff a person owns. So we'll talk a bit about a person's estate and how a person disposes of or distributes their estate. And here we're just talking about the things that belong to someone, the things that a person owns. And so now we're talking about how we own things. I want to talk a little bit about the various legal ways that ownership can be categorized, described, and organized. And so these are various ways to hold the title. And I want to talk first about these top two, the two kind of probably most commonly recognized ways to hold title or ways to own something, just in brief. And that first way here is joint tenancy. So we talk about owning something jointly with someone else. This is going to come back up again a little bit later on. So talking about joint ownership. We'll talk about tenancy in common. That's another way to own something with somebody else. And then we'll talk about a little bit of we won't touch deeply on tenancy by the entirety or community property concepts. These are kind of other ways of owning and passing title, or title transferring. They don't generally, so community property concepts don't necessarily specifically apply here, but those concepts I think are meaningful. But primarily I want to focus on the ways that many folks share title to property, and these are via joint tenancy and tenancy in common. So to take up joint tenancy first, we're talking, I'm already using language that I think is kind of, my thing about language. It's so complicated and complicating. But tenancy, here, we often think of tenancy as related to rental agreements. Here we're talking about use. And when we know within concepts of ownership, we're talking about the right to use, to possess, and to dispose of property. So here we're talking about ownership in that context, and the tenancy refers to that. So joint tenancy is a way of owning a piece of property versus the relationship of tenancy to what we often understand as rental arrangements. So setting that rental piece aside, now we're talking about the shared ownership of property, joint ownership. Joint tenancy is another word for that. And in a joint tenancy or in a joint ownership arrangement, each owner has an undivided interest. So they each own the property, whatever that might be, entirely. And the other important thing to know about joint tenancy is that it creates a right of survivorship. And right of survivorship means that when one of the joint owners dies, the other joint owner becomes the sole owner, or the other joint owners, if there are more than one, take that person's portion into their ownership. So they inherit the co-joint owners share, the deceased owner's interest here. So this is a joint tenancy with the right of survivorship. The other form of ownership I want to talk briefly about as it applies to our real property in Minnesota has to do with tenancy in common. And tenancy in common describes an arrangement in which each owner owns a share of a piece of property. And while I talked about right of survivorship with relationship to joint ownership arrangements, with regard to tenancy in common, these arrangements do not create a right of survivorship. So instead, each owner can give their interest to their own heirs. That means that if I own a piece of real property with my brother, I own that with my brother in an arrangement of tenancy in common, I can give my interest, let's say for the purpose of simplicity, we own 50% interest. I can give my 50% interest to my children. My brother can give his 50% interest to his children. So when he dies, his children and I own the property, or if I die before him, my children and he share that interest. So tenancy in common describes that arrangement. And shares can be of unequal size. So I can own a 1/3 interest in a property and my brother can own 2/3 interest. But despite that unequal interest, we each have the right to use the property in its entirety. So that's another unique feature of a tenancy in common arrangement. And these are two of the most common types of ownership structures, primarily for real property, but also for some other types of assets, such as certain types of accounts. Accounts can be an asset that's titled, and so some accounts are titled jointly and some are titled in other manners. One of the questions that arises often is how marriage impacts ownership, and whether it does. And the fact is that it in fact impacts ownership in some specific ways. The ways that I think are significant for the purposes of our conversation have to do with homestead and real property rights. So we have a circumstance in Minnesota that some people refer to as 1 to buy, 2 to sell. And in Minnesota, one person can enter into an arrangement to purchase real property. But if a couple is married, a spouse is not able to convey real property without the permission or the acknowledgement of the other spouse, particularly if that property is homestead property, so if it's the place where they live. In addition, outside of the realm of homestead, a place, shared real property, a place where people reside, a spouse also has an elective share in an estate. And I know this is getting a bit jargony, so I'll try to walk it back a bit, but we'll be talking in a moment about probate and wills and what it means to inherit. And so if I'm married and I choose to disinherit my spouse, in Minnesota, I may endeavor to do that, but our statute actually allows a spouse to receive what's described as an elective share, so a portion of the deceased spouse's estate, even if they are not acknowledged in the testamentary device in the will. So this is an opportunity then to ensure that a person does have resources available to support them. The general notion behind the elective share, that we don't leave somebody without any resources available to them. So this is just a couple of things about marriage to note. There's the real property signing issue, and then there is the elective share question regarding marriage. So after somebody dies, the things that they own become owned by somebody else in 3 different ways. We'll talk more about this. They can become owned by somebody else through what we talked about, joint tenancy with right of survivorship. So in that case, they might become owned by somebody else because that other person was a joint owner. They might become owned by somebody else through a beneficiary designation. This might be the case, for example, for insurance or for certain types of retirement, that you designate a beneficiary. And when you die, if you own that account or that product, you have listed the name of a person or an entity that you would like to receive the contents of that account or the proceeds of that account in a beneficiary designation. So you've named the person. They don't own a current interest in the resource. They're just the beneficiary after death. So a beneficiary designation, that's a second way that title transfers from the decedent to another person, so that somebody besides the person who died can own the item. The third way that title transfers when somebody dies is through probate. And probate is the way that the court says, okay, this person owned this item without any instruction attached to the item. How now should we make sure that somebody else owns this? And in that process, a will can be like a map for the probate process. So that's where wills come in. But these are the three ways that title transfers. Rights of survivorship there, beneficiary designation, and probate. So what is probate? It's this process whereby who owns what the decedent owned is determined. And a probate court is a court that oversees a probate process. It's a court of limited jurisdiction. So they're specifically, if in your district there's a probate court specifically, they are overseeing these particular questions related to the ownership of somebody's estate. Generally, the probate court will oversee the distribution of somebody's estate based on instructions in their will. And if a person doesn't have a will, then there are statutes that guide the probate administration, that guide the probate court in making decisions about who owns a deceased person's assets. As you can see, the assets that the probate court would have the opportunity to guide the distribution of, or control the distribution of, in fact, are going to be things that are not jointly owned, right? Because that joint ownership has a right of survivorship, so the other joint owner becomes the owner. It's not necessary to engage the probate court around who owns a jointly held asset after someone dies. But then also assets that are not beneficiary designated, because if there's a beneficiary designee, then that person will receive the asset when the owner dies. So we kind of see here the situation in which those certain assets will be probate assets, or will be those things that are owned only by the person who dies, by the decedent at the time of their death, and are not jointly owned and are not beneficiary designated. So those are probate assets, anything I own individually without a beneficiary designation at the time of my death. And then usually, again, I've created a will or given some kind of an instruction about what I want to have happen with that stuff. What is a will? A testamentary document. It's the instruction I'm giving about here's who I want to have. The things that I have not already designated via joint ownership or via a beneficiary designation are going to be things that the will can direct. And then in addition to giving instructions about the things that I own, a will also appoints a person to manage that process. So there's some real value, I think, in identifying both that the will gives a chance for folks to communicate how they would like the things they do not jointly own with somebody else and that are not beneficiary designated, but all those other things, how they would like them to be distributed, but also who is in charge of distributing them. That personal representative language is new. Some folks might call that person an executor, the executor of a will. We tend to call that person a personal representative now, and generally that's the language used by the court. The people who receive things in a will, we sometimes refer to them as beneficiaries. We sometimes refer to them as devisees. That language is not as familiar to consumers, beneficiaries is generally language that consumers are using to describe that role. So just to be aware of that. And so I'm just going to take a pause right here at what is a will, because I see a number of questions coming in the Q&A. Renee, any thoughts on, are there things that could be?
Well, I think that you've answered some of them while they, like, just as you entered it, one was asking specifically between tenants in common and joint tenants, and then you almost immediately went to that answer. So I think you got
Okay.
that. And I think you just answered this
Yeah,
question, if everything is titled with the beneficiary and joint tenancy, what would be a will be needed for? And then I think you immediately went into, like, because somebody manages, and said, I'm going to say that one you got to. But there are a couple of questions about if a business is owned 50-50, can the deceased gift their 50% of the business to someone else?
Well, these are really, so I will tell you,
Details, right?
great questions. Yes, excellent questions. Thank you so much, Renee, for helping me with these and for identifying kind of as they're coming in, how they're if I'm addressing them. Thank you very much. I will say so we're talking probate basics right now, and business transition planning is not a probate basic. If a person
Okay.
owns a business, they should have legal advice specific to their situation. You're going to see that theme arise a little bit from me here. I hate to do that. I don't like that
Yeah.
attorney answer, the it depends answer. But business succession planning is beyond probate basics. So I'm not
Got
even going
it.
to wade into that. There's so much specific stuff that could control whether or not a person could make certain kinds of decisions about a business entity that they own, not least significantly their contractual commitments to others. So, so that's a particular question. Similarly with some of these other specific questions regarding liens, I will talk a little bit about, in a probate situation, one of the things that the court is doing is looking at creditor claims against the estate and helping make a determination about the payment and the order of payment of creditor claims. So certain liens take precedence over other things, and some types of liens do not. I'm going to talk a little bit at the end of our presentation today about medical assistance liens. You will hear me say, I will just prep everyone ahead of time, you're going to hear me say, if you are working with somebody who has concerns about medical assistance, estate recovery, or liens, they need to talk with an attorney. This is an important area where people should be getting very specific advice, and I'll talk about why that is when we get to those questions. But I do want to make sure that we're keeping focused on the probate basics in our discussion today. If you've got follow-up questions that are real detailed or specific, check in with us on the advocacy line. We can get you a referral to an attorney who could potentially answer specific real property or estate planning questions. And then some basics we can help provide legal information around. So I'm going to defer some of our most complex questions to an offline answer, just because I want to make sure that we get through some of the basics today for folks who are newly coming to these concepts.
Absolutely. So there are two basics that are in the chat that I think you can get
Awesome.
to. One is, like, wanting to clarify, this is not healthcare directive. This is an additional document of the will of a personal representative. So we're not talking healthcare directives today at all,
No,
right?
we're not talking. Absolutely. Thanks for clarifying, Renee. We're not talking about healthcare directives. We're not talking about POA. These are lifetime documents, healthcare directives and power of attorney, these kinds of substitute decision-making documents. Today, we're talking about after somebody dies. So really no longer talking about making decisions for somebody who's living. We're talking about what happens to the things a person who has died owns. So that's all our focus for today.
Okay. And a will, does it have to be written and notarized and done by an attorney, or are there more informal options
Great
there?
questions, two great questions. And I see another one there too, Renee, that I appreciate as well, which is, well, so what's the point of a will if you can beneficiary designate and jointly own stuff? So I want to address both of those, the one that you articulated and the other one there, the kind of what's the point question.
When you get to, before you get to that, I just want to add a little housekeeping piece. I will be adding everybody gets added to our email list. You will be getting everybody's email that you use to log into this will be receiving the CEU and the follow-up, and you'll be able to keep up with the future of our webinars Sorry, that's off topic, but it's a lot of inquiry over here in chat.
No, totally, absolutely. It's great to just reflect and refresh that. We know that folks are kind of jumping in as they're able on their lunch break, and grateful for the minutes that you are able to share with us, and happy to have folks coming in, happy to share that information as we go. Oh my gosh, Renee, I did that thing where I talked and then I forgot the first question. Will you tell me again? I'm going to open up the Q&A, make sure that I got
I think they both were about notarized,
Oh yeah,
signed, and
yes, absolutely. Oh, so validity of will is an important consideration. There are lots of resources that can help a person create a testamentary plan. And the best resource for a person to use to create a testamentary plan is to visit an attorney. And the reason I say that is because an attorney can hold in tension a lot of things that other resources are not able to do, sort of simultaneously accounting for, not just the structure of what a person owns, but also the feelings that they have about the things that they own, and the way that they want to address not only a practical plan, but also express feelings in that regard as well. So attorneys can have that insight and can hold that tension for folks. They also can recognize a lot of intersecting issues that can arise in estate planning and testamentary planning related to financial matters, tax issues, family issues. So I just feel that that's the place where I begin with advice regarding how to create testamentary documents. An estate planning attorney also will be able to answer a person's questions about what is the most kind of appropriate estate planning strategy to use. Some people might benefit from a will. For example, if a person does own a lot of items individually, as an individual, not jointly, and has not designated many items to be received by beneficiaries in that context, then that person might benefit from a will, or an attorney advising them might see that they could benefit from a trust type plan. And so that's great guidance to have. And then the attorney themselves can become responsible for ensuring that those documents are properly executed. So that means that the will is written in a way that's clear and understandable and appropriately and legally directs the probate court. And in addition, legally or appropriately appoints a personal representative to take charge of the estate administration. We might call that proceeding, probate proceeding, and estate administration. And that that the signature on the will, for example, is witnessed by two disinterested witnesses, and that if a person desires to execute what's called a self-proving affidavit, that basically kind of corroborates who the witnesses are, that those signatures also be notarized. So there are just a lot of good technical pieces in creating a testamentary document to hold in mind. That being said, I know that oftentimes the follow-up is, can I use an online will creation tool? And the answer is yes, you can do that. You will not receive that same type of individualized advice or guidance, and the online tools are as accurate and as clear as the information that we are able as individuals to provide to them. And so there's a bit of a push-pull there. I just wanted to observe that, if we don't have all the information about about what we own, which we like to believe we do, but sometimes sometimes it can get a little complicated. Then the program creating the testamentary document, the will, is not going to know about those things either. And the program may or may not prompt with questions. So that's another reason I do like to counsel working with an attorney if that's within reason for you, again, because, or for the clients with whom you are speaking, again, because of attorney ability to just spot those issues as they're arising. Tax issues, again, other things that might cause conflict within family contexts, or things within the experience of attorneys who have done estate planning or probate administration. So some valuable, I think, just structural stuff there about creating a will. And then there's this genuine question, why would I go to the trouble of creating a will, especially if I then have to retain an attorney, and if I can just jointly own and beneficiary designate everything. And the answer is, in some cases, there may not be a reason to have a will. But in cases, and in fact, I would venture to say in most cases, um, it's a very simple backup to have in the event that you happen to own something in your own name at the time of your death. Um, that does not have a beneficiary designation attached to it, or for in some instance, if the beneficiary designation is not something that can be realized. Say for example, the person who is named as a beneficiary is themselves deceased. There are some questions there about what might transpire, but a way to think about that type of planning, and a way to think about a circumstance in which a will might be necessary, um, even if uh, uh, otherwise everything has been taken care of in that joint ownership or beneficiary designated capacity. Um, there can be things that we forget about, and it's not at all unusual to forget about, a life insurance policy from a long time ago, or something else that maybe hasn't been updated, maybe doesn't have a beneficiary named, or there might be a reason that a person has not identified those individuals. One question that was submitted, I think I addressed it maybe a little bit later on, is, what happens when a person refuses to create those types of plans or documents. And that can also be something that happens. A person can just really not want to follow through with any of those types of instructions. So that's another sticky spot there. Hopefully those are some kind of helpful reflections regarding the execution process, and just the kind of the questions about whether or not to have a will. It's a fair question, and a question that, again, I think just as when we think about, like, if I have a will that gives a clear instruction and it's fairly straightforward to create it, it does give a lot of clarity and peace of mind to people that are assisting with this process of distributing the things that I owned after I die. So something to consider there in terms of ease for the people that are taking care of this on our behalfs. Great questions here again. I'm seeing lots of excellent questions in the chat. Gosh, I hope I can. I say this to Renee constantly. Let's do it. We'll do another one. We'll do another one. But I do see these questions. 2 questions about married couples who have separate bank accounts. I just want to recognize that that in those instances, that that it's possible to identify effectively a pay on death beneficiary. So to beneficiary designate a bank account. And now I want to make sure that folks understand that there's a difference between adding a joint owner, and the question gets at this, right? But there's a difference between adding a joint owner and adding a person to a bank account as a beneficiary. A joint owner controls the contents of the account and enjoys a full use of the contents of the account. A beneficiary designee does not have a current ownership interest in the contents of the account, but rather simply receives those contents on the owner's death. So see that difference, and just know that there's a difference there. You don't have to remember all the details about it, but if you sense you're getting into some territory where folks are asking questions about what's the difference between joint ownership and pay on death beneficiary, you can call us at the Elder Justice Center, and we'll help explain the difference between joint ownership and beneficiary designating a bank account to you, so that you can help give guidance if your participants are really kind of directing a lot of those questions toward you. You can send them to us as well. And then some great sharing as well, to just hear about just the prices for wills. A person sharing that they had a simple will created for a low price, $100. That seems like a very good value, but perhaps not out of the question. I know estate planning attorneys often will charge a flat fee for the preparation of an estate plan. Sometimes these can be very time-consuming processes. And so, just talking with an attorney about what they might charge for an estate plan, or how they might assess a fee related to that type of work is something that you can certainly do as you're engaging with folks about how this might be how you might accomplish this type of planning. And certainly we can encourage our clients, residents, participants to ask attorneys those questions as well, regarding uh, how much it might cost to create an estate plan or to make a will. A lot of questions too emerging and received regarding avoiding probate. We have a theme in our broader cultural discussion around probate. Of probate is a thing to enjoy, or excuse me, a thing to enjoy, avoid, a thing. So, and I want to, I want to, I want to put a little bit of a caveat around that. Um, in many places, in some, well, I should say in some states, the way that attorneys can charge fees related to probate is different. And so depending on where you are, the way that the cost of probate might be controlled in different ways. In Minnesota, I would simply say, probate can actually be a fairly straightforward process. It can often be handled informally. That means without any court appearances. It can sometimes be handled almost entirely by correspondence. And so I would say that, and then if a probate is fairly simple, a personal representative may not need the services of an attorney to move through a probate process, a simple and informal probate process, but rather the guidance, the self-help guidance from the court would be sufficient to walk through a basic probate process. So in those instances, the only costs associated with probate are the personal representative's time and the filing fees, perhaps related to the court fees in terms of filing, a few $100s usually. So again, when we talk about the range, then of course there are complex probates where a person owned a lot of assets and their distribution is complicated, and it's best to hire an attorney to control or to manage that process, and let the personal representative fulfill their role and have that kind of guidance. And those, of course, can be very time consuming and they can be expensive. So when people talk about using a will to avoid a probate, it doesn't necessarily describe how it actually works. When we use a will to avoid probate, we use a will to avoid like a complex or mysterious probate, ideally, if the will is executed properly. And if it is, then it kind of provides a roadmap to the court. There's not a lot of question or discussion about whether, sibling A owns this item or sibling B owns this item because it was specified in the will. So there won't be discussion necessarily about that. That's at least what the will attempts to avoid. So when we talk about avoiding probate, really, I think those are some of the considerations that folks are making. Not quite as concerning in Minnesota as it is in some states where it's possible for probate proceedings to become more expensive. I do want to, I see a great prompt too. I mentioned briefly pay on death benefits, beneficiaries on bank accounts. Hi, John. I see John commenting. Colleague of mine asking for me to mention pay on death beneficiaries and transfer on death beneficiaries. If a person has a brokerage account or owns stock, it's possible to add a beneficiary to those accounts as well. That's often called then a transfer on death beneficiary. So basically you can see what this does. This allows a person to make these types of accounts beneficiary designated assets. So they are no longer probate assets. They are beneficiary designated. Pay on death beneficiary, transfer on death beneficiary. And in addition, for real property, there is a process in Minnesota called a transfer on death deed. TODD is the abbreviation. We refer to it as a TOD. So transfer on death deed, a TOD, is a way that a person can create what is effectively a beneficiary designation for a piece of real property. Again, we're getting beyond basics when I talk about some details related to transfer on death deeds, but I just want folks to know that that's an option related to real property. A great question here about, does all probate have to go through the courts? Well, I would say all probate has to go through courts because probate is a court supervised proceeding. Probate is a court proceeding in which a person's ownership is determined. And it's the question of legal ownership. So the court is involved in supervising a probate either informally or formally, but not all estate administrations are probates, right? So not all folks necessarily require a probate. Again, if the things they owned were jointly owned, if they're beneficiary designated, then an estate administration is simply a matter of ensuring that those beneficiary designated accounts end up in the right places. And that type of an estate administration may not need court supervision, may not require a probate proceeding. So some things to consider there, again, about language. Don't want to get too confusing, but a probate is a court process. A question here about will's value prior to death, and a will is a document that becomes mature, that vests at the time of a person's death. It does not really make a difference if a person is identified as a personal representative or executor under a will as to what kinds of decisions that individual gets to make during the lifetime of an individual. I think the spot where this gets confusing is often the same person who is a person's attorney in fact during lifetime is the person's personal representative under their will as well. They're named in both documents. And it's kind of because the same type of skills are beneficial in both roles. You know, the organization, decision making, kind of an awareness of a person's financial values, those kinds of things. I think that's where that gets confusing though, because oftentimes the attorney in fact, the lifetime role is occupied by the same helper, the same individual who serves then after death as the personal representative. So oftentimes that same kind of family role there. In Minnesota, attorneys generally don't charge certain percentages of a state's fees. This is what I was talking about earlier. That's in some other states, that is the case, but in Minnesota, that is not the case. So I want to make sure that I move to some of the submitted questions before we run out of time. And I am, again, tremendously appreciating the level of detail and exchange here in the Q&A and chat. Thank you so much for that. I will look forward to engaging over these questions, particularly if they're more complex. Please give us a call. And I want to make sure that I get through some of these basics as well. Again, what is a trust? A trust is a concept that uses the same kind of ownership rules that we've been talking about to hold assets in a different way. When a person creates a trust, the notion is that they as an individual no longer own the asset, but rather they have given the asset or titled the asset into a trust that they control. So now the trust owns that asset. I was about to say it's a complex legal structure. It is actually, because it creates an entity that owns items, and then the entity is controlled by a person who serves as a trustee. That's an individual who's making decisions about the items owned by the trust. It's created by a person whose role is called the grantor or trustor sometimes. And then the beneficiaries of things that are held in trust are called beneficiaries, and they have their own rights related to those items in trust. I'll leave that there for now because that's getting a little bit complex in the estate planning realm, but we can come back to it. Questions about what happens when a person dies without a will. If a person dies without a will, they are in a category we would call intestate, or intestacy is the circumstance in which a person dies without a will. And we have a statute in Minnesota that governs intestacy in our probate code. So it identifies, okay, if a person does not have a will in which they specify, oh, I want this to my this to go to my cousin, and I want this stuff distributed among my children, and I want, etc. That in that case, if a person dies without those instructions, that there's a system of interest, a hierarchical system, children, parents, grandchildren, grandparents, etc., related to heirs and identifying who takes first. And then another related question, what happens when a person doesn't have any heirs? That's another question that comes up fairly often. We think about this sometimes with regard to solohood. What happens when there is not a person to receive these assets? And ultimately, when it comes to the physical disposition of a person's remains, then sometimes counties will have to step into a role to make a decision about that. And then when it comes to the things that a person owns, our intestacy statutes will govern, again, how an heir search unfolds. And then if no heirs are identified, the recipient of the resources is typically going to be the state. If a person did not own very much, this is a reasonable question as well. Oftentimes we know, well, for all types of reasons, a person could find themselves in a situation where they own fewer than $75,000 worth of assets at the time of their death, and they did not own real property that's only in their name. So then we have a very simple proceeding called an affidavit of collection that a person may use as a effectively as a personal representative in what would be a, a low-key estate administration. So still court supervised, but not a full-fledged probate with all the related notice because of the smaller amount of assets that were owned at the time of death. That affidavit of collection empowers that personal representative to gather up the remaining items that an individual did own and distribute them according to that person's instructions. Those instructions likely coming in the form of a will. The question came up about whether or not a person can disinherit their adult family members. And then the answer to that is yes. I think this gets into a question that was alluded to maybe in the Q&A regarding the ability of one spouse to disinherit the other. And the elective share is controlled by statute. So what a spouse can actually do in terms of disinheriting is statutorily controlled. Again, here we're a little bit outside of the basics, but what I want folks to take away from a basics discussion related to elective share is that it exists. So while we might intend to disinherit somebody, if we are married at the time of death, that person will be allowed to benefit from my estate in some way. And the way in which they benefit is controlled by statute. The way that distribution occurs is based on the length of time that people have been in marriage relationship. Often receive this question. I talked a little bit about this in terms of estate planning, flat fee estate planning. Some folks say, how long and expensive is an estate administration or a probate? And again, it depends so much on complexity, the complexity of the estate, how many assets and in how many different ways they were maintained, how many beneficiaries, and how well the personal representative is able to work with beneficiaries on the administration. All these things come into play as to timeliness. So those are just some general considerations to make at the basic level related to time and expense. And if folks are asking you questions about how expensive an estate administration is going to be, again, I try to encourage folks to reach out to attorneys. Attorneys should be able to give not concrete, not committed information, but just a general estimate or some general information about their hourly rate, how long typical, or I hate to say typical because nothing is typical, but how long a probate in their experience might take that was based on the ownership of similar types of assets, those kinds of things. So in particular, just a valuable opportunity to, again, pose that question. Here we are at MA Estate Recovery and MA Liens. I want to mention this because we've received a couple of questions related to estate recovery. So estate recovery occurs when a person's received medical assistance. It's what we call Medicaid in Minnesota. And in Minnesota, county agencies can file claims against the estate of a medical assistance recipient or their spouse's estate. And DHS can file liens against real property interests of the recipient related to the medical assistance payment they received. So so this is a kind of a complex area. I'm going to share a little bit of this information in the slide set with you, but I really want you to understand too, if folks are asking you detailed questions about estate recovery and how that's going to impact their family, they should be sitting down with a long-term care planning attorney and hearing from a person with some specific insight about their situation, because there are exclusions or exceptions to estate recovery that can apply in certain circumstances. For example, if somebody has a spouse or an adult disabled child residing in the homestead, and really wanting to make sure that people are getting good individualized advice around how to plan related to medical assistance. That's really, really critical. So if you're worried or concerned about those kinds of questions coming at you and you're looking for a resource, we can help to get folks connected with people who may be able to help them, other attorneys who might help with long-term care planning, or folks, attorneys who may be able to give advice around estate recovery and MA liens. But these are complex planning areas that families really need to get good advice around. I will also share, there's a link here on the bottom of the page, and I want to point out that link there for folks who are looking for more comprehensive information and examples related to MA liens and estate recovery. Keep old papers for 7 years. Again, noting the difference between old grocery lists and tax documents or estate planning documents. Renee, hi, it's 101. We are imposing on other people's time. And I am just so tremendously grateful for the great questions that are coming in here and the great discussion that's happening. I'm slowly moving through the last of the slides.
Well, I think that what we're faced with here is that this is a really complex and has a area of practice, and this basic kind of gets more questions rolling, right? Like that we want to know, and there's so much particular to a specific case that probably can't be addressed in this way, but we certainly know there are ways to reach out and receive some support to kind of touch base on those challenging specifics. We didn't get to all of the questions, and some of them did move outside of that basics that you were hoping to cover. People are staying, they're jumping off. If there's some final things you want to get to before we close up, I'm not bumping you out, but I was noting that it was time.
Absolutely, totally get it. I'm happy to jump on just a couple last things for folks who want to stay. Great question about whether trusts are irrevocable or revocable. It depends on how you want to pronounce it. I hear it from attorneys both ways. Some are and some are not. Everything in a trust is dependent upon the language of the trust itself. So if we're investigating questions related to trusts, we must see the trust document itself. I want to see all of the language that it contains, want to see what it's called, want to see the rules. So some trusts are revocable or revocable, some trusts are irrevocable and cannot be revoked. So some things to consider then with regard to trust planning. Transfer on death deed question about difference between life estate and transfer on death deed. Again, a little bit more advanced kind of estate or ownership planning. A life estate gives a person a right to use a property during their lifetime. And a transfer on death deed is basically the opposite of that. That's giving a person an ownership interest after the owner has died. So they're kind of like mirrors or two sides of the same coin or something like that, if you'll bear with me for those analogies. And then just lastly, Renee, before we jump off, two questions I think are critical and great questions. Again, what happens if a person receives a lump sum inheritance and they are receiving certain kinds of benefits? And the answer, I think the person asking this is knowledgeable about the pitfall that this can represent, is that a person can become disqualified for the purposes of receiving certain benefits by receiving a lump sum inheritance. So another situation in which people really want to do some specific planning. If a person that may inherit from you receives these types of benefits, SSI, certain kinds of housing benefits, you really want to think about what it might mean for that individual to inherit either from you or from somebody else in their universe, in terms of the receipt of those benefits. And people should get good legal advice around that kind of planning. And then finally, when somebody refuses to plan, and this comes up a lot, especially somebody who owns, real property or significant personal property, and we say we try to support why that person may be resistant to planning, and explain the benefits of planning as best we can, refer to folks who might be able to explain. You can refer to us if it's helpful. I have a colleague in our office who has and I had just great conversation with the advocacy team about this just about an hour or 2 hours ago, just talking about therapeutic self-disclosure, about the benefit of having some of these plans for oneself. We try to limit self-disclosure in the advocacy mode sometimes, but here we might have an opportunity to say, gosh, I did this and it was not as time consuming as I thought it would be to do, or after I've done it, I've been feeling really great that I have a plan in place. I might, one of my colleagues in our office shared a story about simply saying, hey, I'm an example of a person who has an incapacity plan, and I'm not, I haven't relinquished any control over my life by doing so. I am just glad to have it in place. So anyway, that kind of self-disclosure. And then all kinds of peer support opportunities. We know that peer support is meaningful for all of us. And if we know of communities where these questions are being discussed, or these resources are being explored, social groups, community groups or community centers, any places where conversations might be happening about estate planning, end of life matters, or caregiver support, these could all be environments where a person might receive support and encouragement to make a plan. So just a few final thoughts there. And again, tremendous thank you to everybody for sticking with us through the hour and beyond. I know how precious everybody's time is. So thank you to everybody for that.
I want to note too that in some of these questions and some of the starting points too, refer back to last week's webinar where we had Amy talk about how to find legal help in Minnesota, and that there are a lot of forms and a lot of options that exist out there within the system itself that can kind of be a starting point. So look back to our videos. All of these are recorded on our website. As you exit out, there is a question about POAs that will be coming up as a Q&A in March. So there's opportunity to come back and spend more time about the POA piece. So with that, I think that's everything I have. Take that survey when it pops up, everybody, and you'll get these slides to be able to look at these resources here that are at that last slide that's up there right now. Any final things, Mart? I'm sorry to rush you off.
No rush. I thank you for your patience, Renee, and just thanks again to everybody for joining us today.
Yeah, thanks. And I see there was an active chat too, which I kind of caught here and there. Thank you, everybody, for your contribution to the discussion. Really have a great rest of the day. Bye.